The concept or the definition of a trust receipt transaction. A trust receipt is a document executed by and between a person referred to as the entrustor and another person referred to as the entrustee, whereby the entrustor, who owns or holds absolute title or security interest over specified goods, documents, or instruments, releases the subject goods to the possession of the entrustee. The release of such goods to the entrustee is conditioned upon his execution and delivery to the entrustor of a trust receipt, wherein the former binds himself to hold the specific goods, documents, or instruments in trust for the entrustor, and to sell or otherwise dispose of the goods, documents, or instruments with the obligation to turn over the entrustor the proceeds to the extent of the amount owing to the entrustor, or the goods, documents, or instruments themselves if they are unsold. Okay? So in here, the entrustor is entitled only to the proceeds derived from the sale of goods released under a trust receipt to the entrustee. Kindly read the case of Sinang versus People, 619 SCRA 291. The true nature of a trust receipt transaction can be found in the whereas clause of the Presidential Decree 115, which states that a trust receipt is to be utilized as a convenient business device to assist importers and merchants solve their financing problems. The state sought to find a way to assist importers and merchants in their financing in order to encourage commerce in the Philippines. Remember that a trust receipt is inextricably linked with the primary agreement between the parties. A trust receipt agreement is merely a collateral agreement, so the purpose of which is only to serve as a security for a loan. The trust receipt, is a separate and independent security transaction intended to aid in financing importers, whereby the imported goods are held as a security by the lending institution for the loan obligation. Example, a case, C contracted D to renovate his commercial building. D ordered construction materials from E and received delivery thereof. The following day, C went to F Bank to apply for a loan to pay the construction materials. As a security for the loan, C was made to execute a trust receipt. 1 year later, after C failed to pay the balance on the loan, F Bank charged him with violation of trust receipt law. Will the case against C prosper? Why? The answer: the case against C will not prosper. This situation belies what normally obtains in a pure trust receipt transaction, where goods are owned by the bank and only released to the importer in trust subsequent to the grant of the loan. In this case, the bank acquires a security interest in the goods as a holder of a security title for the advances it had made to the entrustee. The ownership of the merchandise continues to be vested in the person who had advance payment, until he has been fully paid. Or if the merchandise has already been sold, of course, the proceeds of the sale should be turned over to him by the importer or by his representative. To secure that the bank shall be paid, it takes full title to the goods at the very beginning and continues to hold the title as his indispensable security until the goods are sold and the vendee is called upon to pay for them. Hence, the importer has never owned the goods and is not able to deliver possession. In the given case, okay, sa binigay na case, C received the construction materials from E before, okay, or prior to the execution of the trust receipt transaction. As such, the transaction given is only a simple loan and not covered by the trust receipt law. So under the trust receipts law, there are two acts or omissions penalized. Okay, one is to failure to turn over the proceeds of the sale of the goods, and second, failure to return the goods covered by the trust receipts if the goods are not sold. Question: is lack of intent to defraud a bar to the prosecution of this acts or omission? Is the lack of intent to defraud a bar to the prosecution of this acts or omission? The answer is no. Okay, the mere failure to account or return gives rise to the crime, which is a malum prohibitum. Hence, there is no requirement to prove intent to defraud.